Hello everyone, and welcome to the second of our video tutorials on negligence. Today we're going to be looking at breach of duty. Just a reminder that in order to find the defendant liable in negligence, we have to prove the three elements. Firstly, there was a duty of care. Secondly, there was a breach of this duty. And thirdly, this resulted in damage to the claimant. In our last video tutorial, we looked at duty of care, and today we're going to focus on breach of duty. Breach of duty in negligence occurs where the defendant fails to meet the standard of care required by law. Once it has been established that the defendant owed the claimant a duty of care, the claimant must also demonstrate that the defendant was in breach of duty. And the test of breach of duty is generally objective, but there may be slight variations to this. General objective standard of care is the standard of the reasonable man. So when we're deciding whether the defendant has breached his duty of care, we are looking at whether he has done what a reasonable man would have done. This objective test comes from the case of Blyth and Birmingham Waterworks, and the judge explained the reasonable man test. And he said, negligence is the omission to do something which a reasonable man would do, or doing something which a prudent and reasonable man would not do. So in general, when we're trying to decide whether someone's breached the duty of care, we just say, would a reasonable man have done what they did? However, as I've just mentioned, sometimes that objective standard can change slightly. And it says here on this slide, in some situations, the standard is not purely objective, and sometimes we take into account certain characteristics of the defendant. So we need to consider, what if our defendant's a child? What if they're a learner? What if they're a professional? So we're going to have a look at the key cases on this. In the case of Mullin and Richards, we had 15-year-old girls and they were play fighting with plastic rulers. And one ruler snapped and blinded one of the girls. And the issue was, had one of these schoolgirls breached her duty of care? And the court decided in this case that a child is not expected to meet the standard of a reasonable adult, but will be judged by the standard of a reasonable child of that age. And that seems like a fair rule to have. It will be unfair to expect children to exercise the same degree of care as a more experienced adult. So we judge them by other children of their age. Sometimes your defendant might be a learner, and their argument is going to be, well, I know I've made a mistake here, but I'm only learning, I'm new to this, so I haven't breached my duty because I'm not very experienced. And this was the argument that the court had to consider in the famous case of Nettleship and Weston. And here our defendant was a learner driver, and during her lesson, she mounted the pavement and hit a lamppost. And her driving instructor fractured his knee. And the issue was, did she breach her duty? And you can see here that the principle is that a learner driver is expected to meet the same standard as a reasonable, qualified, competent driver. Now that seems like a very harsh rule to have, but of course it's for the practical reasons that we can't be altering the standard that we expect depending on how long someone has been doing something. There would be real practical difficulties if defendants could say, oh, well, I've only been doing it 2 months, or I've only been doing it 6 months, or I've only been doing it a year. We'd have to be comparing them to people who've been doing whatever it was they were doing for different periods of time, and that would be unpractical. And it would also be wrong if we were expecting a lower standard of care from a junior doctor than from an experienced doctor. So therefore we have this rule that whatever it is you're doing, you should be exercising the same degree of skill and care as a competent person. And of course, they can always ask a more experienced person for help. So experts then, this again could potentially alter the standard of care expected for breach of duty. If the defendant is a professional, they're going to be held to the standard of a reasonable person within that profession. And that's illustrated by the case of Bolam and Frame. And in this case, our claimant was undergoing ECT, which is electroconvulsive therapy. Now, the doctor didn't give him any relaxant drugs, and so when he was having this ECT, he actually suffered a serious fracture. And the issue was, had the doctor been negligent? Had he breached his duty? And the court said that the standard for experts is that of a competent expert in that particular art. And they also said in Bolam, rather controversially, that it's not negligent if another expert would have done the same. So because this doctor could find other doctors that would have done the same therapy as him without relaxants, he had not breached his duty. As well as considering any special characteristics that the defendant has, when looking at breach of duty, the court also looks at risk factors. And the risk factors can have the effect of either raising or lowering the standard expected from the reasonable person. So the more risk factors there are, the more likely the breach. The fewer the risk factors there are, the less likely the breach. And this will make sense if we look at some cases. The first risk factor that the courts will consider is the size of the risk. So how risky was the activity? And we've got Bolton and Stone here. And what happened was that there was a cricket ground and a cricket ball was hit out of the ground and it hit a passerby in the street. Now, the court looked at the situation here and found that there was a 17-foot high fence and the wicket was 100 yards away from the fence, and that balls had only been hit out of the ground a total of 6 times in 35 years. So these facts here are showing that it was actually low risk. It was not very likely that a ball was going to go out of the ground. And what the court said is if there is a low risk, there may be no breach of duty. And here, the likelihood of harm was low, and our defendant had taken all practical precautions you could expect of them. They had a high fence, the wicket was a long way away from the fence, and that was reasonable enough. So there was no breach of duty there because it was low risk. It's nice to contrast that to a high risk situation. So we're going to look at Haley and the London Electricity Board here. Remember Haley then, our claimant was blind and he fell into a hole made by construction workers who'd only left a hammer across the pavement as a warning that this hole existed in the pavement. Now, the court said here there was a breach of duty because there was high risk here, which was known to the defendants. The board were aware, the electricity board that is, the electricity board were aware that a large number of blind people walked unaided down the street, and therefore leaving a hole in this way was high risk and they had breached their duty of care. So we've looked at high and low risk. Another risk factor the courts consider is magnitude of the harm, and this is sometimes called having a vulnerable victim or a vulnerable claimant. And in Paris and Stepney, our claimant was blind in one eye, and he was a mechanic and he wasn't given any protective goggles by his employers. And whilst working, unfortunately and rather ironically, some metal went into his one good eye, which left him totally blind. And the court looked at this and they were trying to decide whether his employers had been negligent, whether they had breached their duty. And the court said that the magnitude of potential harm was greater for Paris, so therefore more precautions should have been taken. So in other words, his employers knew that he was very vulnerable. He only had one good eye, so any harm to his other eye, to his good eye, would be very serious. So more precautions should have been taken. And they also pointed out that the cost and effort of providing goggles was very small compared to the magnitude, the severity of this risk. And Paris links quite nicely to Latimer on practicality of taking precautions, because in Paris they pointed out the cost of providing goggles would be quite small. Now, in the case of Latimer, we had a factory floor that was flooded and an employee slipped up and was injured. But the defendant who owned the company had put up warning signs, mopped up, placed sawdust down, and it was held that there was no breach of duty here. So the court said that our defendant only has to take reasonable precautions to minimise the risk. Now, what's reasonable will depend on the situation. Here, it was reasonable to have done these things, but if you think back to Paris, it was unreasonable not to give him goggles because they were so cheap and easily available. The court said there's no duty to close the factory here. That would have been the only way to totally prevent anyone slipping. But that wasn't proportionate to the risk that they had responded to. Our final risk factor that we'll consider on breach of duty is whether there's any potential benefits of the risky activity. And in Watt and Hertfordshire, there was an emergency where the fire brigade were called to an accident where they needed to lift a lorry from a car. Now, there was a special fire engine that had a jack that would transport the equipment. But unfortunately, that was already out. So the fire brigade had to use a different lorry. And a fire officer was injured when the jack fell on her leg because they were in the wrong type of engine. There was held to be no breach of duty here. And that was because there was an emergency. And in an emergency, you are allowed to take more risks than you would in a normal situation. And the court in Watt said the emergency of the situation and the utility, the usefulness of their conduct in saving a life outweighed the need to take precautions. So if there's an emergency, our defendant can take more risks. So we've looked at all the cases that we need to look at on breach of duty now. So I've just got a summary of what I've just run through up on the slide. So when you're looking at breach of duty, we start off with the reasonable man test from Blyth and Birmingham Waterworks. So the standard owed is that of the reasonable man. And generally, this is an objective test. So when we're deciding whether someone's breached their duty, we just say, would a reasonable man have done the same? But what we've seen is that standard may alter slightly depending on whether the defendant has particular characteristics. So children are judged by other children of that age. Learners must meet the same standard as someone competent and experienced. And experts are judged by other experts in that art. We've also looked at risk factors. So the more risk factors there are, the more likely the defendant has breached his duty. If it's low risk, we've got Bolton and Stone, less likely to have breached. If it's high risk, we've got Haley, more likely to be a breach. If you've got a vulnerable victim or a high magnitude of harm, more likely a breach, that's Paris. Practicality of taking precautions, that comes from Latimer. So our defendant only has to do what's reasonable in the circumstances. And in Watt, if it's an emergency situation, our defendant is allowed to take more risks. So in summary, standard of the reasonable man is objective, but we might tweak it slightly to take into account characteristics, and we will also consider the risk factors. So that's breach of duty. Please watch the next video tutorial on negligence, in which we'll be looking at the third element, which is proving damage.